Hello everyone. Today I wanted to go over the next part of the police stop series. And this is going to deal with the stop itself. The first thing we're going to bring up is the fact that we've spoke about probable cause. We just touched the surface of that. We spoke about exactly what a crime is. And now we talked about sure versus Cullen. Now I want to dig a little deeper because again, we're still at the beginning of the stop. And this is just for knowing, because the more you know, the more you're able to defend yourself when asking proper questions. We also spoke about the police amendability to you, the citizen. And next part we're going to deal with, because I also spoke about if they choose not to do what you ask them to do, because they are the public servant. There's one part of articulating probable cause, which, if it does not deem a crime, it becomes a misapprehension of law. Because, again, they're code enforcers, not law enforcement. And what I mean by that, there was a case, Terry v. Ohio, in 1968, and no judicial opinion can comprehend the protein variety of the street encounter with when a reasonably prudent man in circumstances would be warranted in belief that his safety and the others was in danger. Well, whenever you hear the words, they have to articulate what exactly the crime was. If they are unable to do that, because they must be able to point to the dangerous area or the crime itself, because they've either witnessed it, they have a written affirmation that is signed by the complainant, or they have an oath that is signed from a judge, which will be a warrant describing that particular person, place, or thing. If not, it is a Fifth Amendment violation because it violates the Terry stop, and it also violates their oath because now they're acting outside of law. They're acting outside of their state constitution. They're acting outside of their oath. It is also an insurance fraud case because they are bonded and insured to make sure they do the right thing. And with that, I spoke about suing them in federal court because their immunity is waived via United States Code 151122. And one of my favorite cases that I've used several times, and it makes it easy because I'm going to say some things later in videos that's going to blow your mind, because when I say them, it's going to go against everything that you're taught to believe. And the one thing of that is, my case that I like is Delaware v. Prous, 404 U.S. 648, 1979. The United States Supreme Court held that a police may not stop motorists without any probable cause to suspect crime or illegal activity to check their license. If they are doing that, it is automatically a violation. Statutes and codes are not law. And I'm going to speak to that also. Now, real quickly, we're going to go over the first part of what we spoke about. We spoke about probable cause. They need probable cause of a crime. We also spoke about what a crime was. We also spoke about what happens whenever you ask them questions, because they are amendable to you at all times by the oath that they've taken as an executive officer. We've now spoke about they cannot stop you without being able to articulate a crime that they've either witnessed, they have in writing, or they have credible witness that they've used prior that's giving them good information. And if none of those exist, there is no need for an ID. And as we go through this series, you're going to learn step by step what to ask, when to ask, how to ask. And there is never a time that you should find yourself being upset, because the only thing that can happen is that they can aggravate you. That will be it. Do not allow yourself to be taken out of the place of peace, because I've heard the saying a lot of times, knowledge is power. That is absolutely false. Knowledge is potential power. Applied knowledge is power. We're going to make this simple so you can apply it if this situation arises for you. So stay tuned for the next video in this series.